Here is a roadmap for settling an Indiana injury claim. Now, whether you've been in a car crash, slip and fall, or dog bite, the path to settling an injury case is the same for all of these, at least the general path. We're going to give like a bird's eye overview. And the idea for this is to kind of guide a person onto what to expect in their Indiana injury claims process. So let's start off. Whether it's a dog bite, whether it's a car crash, whether it's a slip and fall, the person who's been injured or their attorney needs to let the other person know that they're making a claim. So with the car crash, typically there's a police report and it's very obvious who the insurance company is, or at least it's obvious who the person that caused the crash. With a slip and fall, it may not be as obvious, but if you fall at Walmart, if you fall at Kroger, if you fall at Menards, okay, I was injured at this Menards, and we can make a claim to their legal department, attention legal department. Now, in the event of a dog bite, it may not always be as obvious. In fact, if it happens in an apartment complex, it can get messy really fast. But assume we know the person who owns the dog or other animal that bit us. We'll let them know as well. Hey, here's the letter of representation. With dog bites, sometimes we have to get property records. We have to try to figure out who actually owns the building. Is it rented? Is it owned? Anything like that. Was the dog visiting? Was a dog commonly there? It can get a little bit more messy with slip and falls and dog bites, but there are ways to get it done. We have to let the person who is at fault know that the injured person is making a claim. That's typically done through a letter of representation. That's what we send as attorneys. Now, the most important thing in all of this is, in Indiana, there is a 2-year statute of limitations, and that means a claim must be made within 2 years, or that claim can never be made, absent some extraordinary circumstances that probably don't apply to you. So 2 years and 1 day, you're out of luck. And that means a lawsuit has to be filed within 2 years, if a lawsuit has to be filed. Now, if a government agency is involved, a tort claim notice must be served generally within 180 days. That is like a mini statute of limitations, and then the 2 years still applies on top of that. So it can get a little bit messy, but all the things we're talking about, if the case drags on, if the case for some reason can't get settled, and you're getting closer to that 2-year date, well, a lawsuit has to be filed. You can still negotiate past that 2 years, but at that 2-year mark, if something isn't filed, the other person isn't going to honor any kind of claim because they don't have to. Same thing with a tort claim notice. If it's against a government agency, it's almost best practice to file a tort claim notice immediately so that something is not lost in translation. So, super important, those two huge deadlines, which are basically impossible to overcome if they're missed. Now, settlement in an injury case in Indiana depends on one of two things. The first thing being, well, a person is finished with medical treatment. Now, settlement for an injury case generally can't begin until a person who's been injured is done with medical treatment. Insurance companies might try to tell you, oh, we'll give you a couple of $1,000s for pain and suffering. We'll continue paying the medical bills. That's the biggest trap and lie available to insurance companies, because once they've paid you that settlement, they're going to fight you like, oh, heck, on those medical records. Is it really related? Are you sure it's related? Didn't you have back problems before? We shouldn't have to pay for a bad back forever. This is getting ridiculous. Don't fall for that trick. Now, the second situation where you might be able to settle a case before medical treatment is finished is if all available insurance will never compensate the person who's been injured. We're talking extraordinary injuries or very serious injuries that maybe aren't extraordinary, but a very low policy. And that does happen in Indiana. Indiana has an insurance policy for automobiles where a person has to have $25,000, $50,000. It's called minimum coverage, meaning if the person gets into an auto accident, there's at least $25,000 available for the injured person. And if there's multiple people in the car, well, there's $50,000 subject to each person only getting $25,000 tops. So there are situations where, the person's in a car crash and they take my ambulance, they break a bone, head injury, traumatic brain injury, that their bills easily exceed $25,000. Well, guess what? You don't have to wait till you're finished with treatment to obtain that $25,000 settlement available from the insurance policy, because the reality is that policy will never compensate the person that's been injured. So there has to be one of those two factors present before negotiations for settlement can occur. The person is finished with medical treatment, or there's not enough insurance to make the injured person whole, and they need to pay up because there's no point in waiting. And that brings us to another situation where it's important to know all available insurance. I will tell you a story that actually occurred at this law firm. We had a case where an individual was walking outside of Kroger and they were backed into. The person that backed into them had a very small insurance policy. And the person that was hit, well, they were seriously injured and they were a little bit older, so they're a little bit easier to break. Now, we knew that the person that hit her had insurance. We knew that Kroger had insurance, and we made an argument they didn't have proper lighting and they didn't have proper pathways, especially when it was raining like it was. And we're trying to figure out how to get our injured client who got backed into maximum compensation. So we're talking with her about, well, what policies do you have? What policies have you purchased? It turns out she purchased a $2 million injury policy 25 years ago. And so we were able to get into that policy to try to make our client whole. And that was at a jury trial. This story had a happy ending because at a jury trial, a jury of her peers awarded this senior citizen $3 million for the significant injuries she received when she was backed into in a Kroger parking lot. So always try to find the most insurance possible. It's not always obvious. With the stores, there might be maintenance, there might be the owners of the store, there might be the actual provision. So Menards, Kroger, Walmart, a lot of these places don't own the land that they sit on. They in control of it. So usually there's a company that owns the land, there's the store itself, there's usually the maintenance, if there's snow, ice, or anything like that involved. There's so many things that have to be explored. And never give up on insurance until you know there is nothing else, because people are not very forthcoming with their available insurance policies. They want to try to keep that in their back pocket because they don't want a person trying to get into those. So a person always has to know what insurance is available. Now, once a person's finished with their medical treatment, the next step is presenting a demand to the at-fault person's insurance company. And so the demand is typically the medical records, medical bills. It's the lost wages attending treatment and whatnot, or maybe they weren't able to work. There's some other things in their diminished earning capacity. They're never going to be able to do the job they wanted to do, so there's mobility issues. And there's other things to be considered as well. But then once that all that information is gotten together, along with pictures, x-rays, anything you can imagine, it's submitted to the insurance company for the at-fault party with the number. Hey, we think this number is sufficient to make our client whole for the injuries that they received. Now, the insurance company can respond and say, we don't agree with that number. They're going to try to attack it. Hey, there wasn't enough treatment. She delayed in getting treatment. Didn't listen to the doctor's advice. She already had prior health issues before this. They're going to say so many different things. And that's what insurance companies do. They just fight everything tooth and nail. That's okay. That's why you have attorneys. So we can fight on behalf of the person that has been injured. But at some point, one of two things happens. Either the insurance company and the attorney for the injured individual agree on a number, or the attorney files a lawsuit and says, hey, we can't reach an agreement. We want to go forward. Now, once a lawsuit is filed, that's complaint, appearance, and summons. Those are the three requirements of a lawsuit in Indiana, and payment, of course. Court's got to get paid. Everybody has to get paid, right? At that point, discovery starts. And discovery is interrogatories. It's requests for production. You can even visit the site of the injury. You can inspect vehicles. You can inspect surfaces. You can inspect anything you want. There's all sorts of things for discovery. And each side is allowed to engage in discovery. And they have to be truthful. Indiana has long said trial by ambush is no longer allowed. So parties have to be truthful in discovery. Have you ever been injured before? How many times have you been to the doctor for this particular thing? Has your back, which you're claiming is injured now, ever been injured in the past? We want all your tax returns for the last 10 years. We want all your medical bills, even if they're not related to this incident, because we might say your back was hurt in a prior injury. They can even ask about prior accidents, prior claims. There's so much stuff that can happen in discovery. And then we can ask information too. Have you been a bad driver your entire life? Did you know that a bunch of people have been hurt at this same exact crosswalk numerous times? Oh, your dog has a history of biting people. So discovery works both ways, and both parties get to deal with this. Now, some counties, including Marion County, home of Indianapolis, have mandatory mediation before trial date. Mediation is an avenue the courts like and favor because it's an opportunity for a detached mediator to kind of look at both sides, the injured person, the person that caused the injury, and figure out, hey, can we get this case settled? And sometimes this neutral mediator can help kind of guide things. Now, these mediators typically are very experienced injury attorneys for the defense or the plaintiff. Sometimes they're retired judges. The really good ones are just, they're really good at this, and they're able to say, hey, I've done 100 trials. I can tell you X, Y, and Z is going to be a problem. They'll tell it to both sides. Let's figure this out right now, because if we go to trial, you put your fate in the hands of your peers. Whereas if you decide on what you want now, you know what's going to happen. You don't have that uncertainty. And mediation generally is cheaper than going to trial. We have to pay a lot of people to come. Doctors want money, show up for trial. That's crazy, right? But they do. And it's getting experts to trial. Everything's very complicated, lots of moving parts. Now, we love jury trials at this law firm, but they are stressful. And that's a good kind of stress, and we love it. We signed up for that. But a lot of people don't want to do that. So mediation is an excellent chance to try to resolve a case prior to trial. Now, if mediation fails, guess what? Time for the big show. And a trial, the person that's injured has to prove their case by a preponderance of the evidence. Meaning it's more likely than not that person caused the injury, and these medical expenses, these lost wages, anything you're claiming as a result, it's more likely than not resulted from the injury that the at-fault party caused. And jury trial, honest to God, are the funnest thing for me, for this law firm. Sometimes they're stressful for the clients. Now, just because a case does not resolve that mediation, the parties can still work behind the scenes, and they're always generally working behind the scenes. Even during discovery, we're typically talking with the insurance company. Well, hey, you saw that. Why don't you give us more money? Or they'll be like, hey, Mark, now that you know X, Y, and Z, don't you agree that's too much? But there's always negotiation going on. But mediation kind of is like it's a line in the sand. Now, it's not a solid line. It might be like a dotted line. You can still try to resolve things after that. But that is kind of like a last-ditch effort to get things going before a jury trial. Now, at a jury trial, they're going to hear the evidence. They're going to decide, hey, this person was or was not injured by that person. This person is going to get X, Y, and Z. And they can write whatever number they want on there. Now, attorneys will suggest numbers. Typically, defense is suggesting 0. Or if you want to give them something, give them a little. We obviously want maximum value for our clients' injuries because nobody chose to be injured because somebody else was careless or negligent. That is kind of an overview of the Indiana injury claims process and how to get your case settled in Indiana. Obviously, I'm an attorney and we represent lots of people that have been injured in the state of Indiana. And, we recognize, we hear it all the time, my injury case is causing me so much frustration. This is so hard. Well, allow the Marc Lopez Law Firm to turn your frustration into compensation. Give us a call, 317-632-3642. We would love to help you.